Good morning, everyone. Thank you for joining us today on our webinar on PAGA claims. Just a little fun fact. According to the data maintained by the California Department of Industrial Relations, the number of PAGA notices filed has increased exponentially over the past 2 decades. The number has actually grown from 11 notices in 2006 to almost 9,500 in 2024, which represents about an 86,000% increase, hence the reason for our webinar today. So I want to get you guys really informed because we think that this is going to be an increasingly important area of risk mitigation for employers. And so we want to give you all the facts to be able to empower you to make good business decisions and use your resources appropriately. A few housekeeping items. One, the webinar is recorded, so we will make it available to you shortly after the webinar is completed. If you've got questions, please pop them in the chat. We want this to be interactive and get as many of your questions answered as possible. And so you'll see in your screen an opportunity to just put questions in there, and I'll make sure that the panelists are able to answer those questions. And so without further ado, I would like to introduce our panelists. We have Sam Sherman, who is a partner with TencerSherman LLP, and his practice focuses on defending and advising California employers on various aspects of employment law. His advice practice involves assisting employers on compliance with California's labor and employment laws, drafting employee handbooks, auditing employee and independent contractor designations, separation agreements, and all other areas of employment law. Sam also specializes in defending corporations in employment-related lawsuits, and this work ranges from defending employment claims alleging individual and class action wage and hour violations, as well as individual claims for harassment, discrimination, retaliation, and wrongful termination. We also have Joelle Verbasto, who is a senior finance consultant with PBO Advisory Group, and she's a finance executive that has over 20 years of experience, including over 8 as a CFO. As a senior finance consultant with PBO Advisory Group, Joelle has provided insight and oversight and recommends improvements within the accounting department and has experience in public, private, government, nonprofit, and startup sectors. She has extensive experience with financial and budget reporting, problem definition and resolution, internal controls and systems implementation, HR, payroll, banking, and investment relationships, and staff development. And last but not least, we have Nicole Devine, who is our Consulting Chief People Officer with PBO Advisory Group. Nicole offers more than 19 years of strong HR general background, has also co-founded a small startup consumer products company, and also adds invaluable balance to her business acumen. She's been accountable for all aspects of business and is well positioned to see the human capital management component from every department's perspective. As a Chief People Officer at PBO Advisory Group, Nicole works closely with leadership teams, allowing her to progressively align HR objectives within an organization. So with those, thank you very much, panelists, for joining us today. And with that, I'm going to hand it over to Sam, who's going to give us a bit of an overview about PAGA claims.
Outstanding. Thank you, everyone. Is this just to confirm the screen is showing correctly?
Yes. Okay. Excellent work.
Awesome. Well, thank you very much for having me. Thanks, Fran, for the intro. The lengthy intros are always a little bit ego massaging. So thank you. So yeah, we do a lot of work around this PAGA space. I've given this presentation several times because this is definitely a hot area of the law, and as Fran mentioned, it's only getting more and more prominent in my space. I always tell prospects and clients that PAGA has probably been a three-headed monster, and in the employment law space for a while. So I think the format today is definitely going to be to talk about PAGA. I'm going to spend some time early on just kind of explaining what PAGA is a little bit, not to turn you all into employment lawyers, but just to make sure we have that baseline of knowing kind of what we're talking about here. Talking about the prior law and why that was so cumbersome. And then we'll talk about what the legislature did last year to try to make things a little bit easier on employers. I know some of the people on the labor side that negotiated this, and you know, they're convinced that this was going to be, you know, the death knell of PAGA. I don't think that's true, but there's definitely some things we can take advantage of, and so we'll talk about that. As Fran said, I encourage you all to jump in with questions. Let's make this interactive, and I know the panel will jump in at times as well. So with that, all right, so like I said, we'll talk about what PAGA is, why it's so bad, what the changes are, and what to do going forward. So PAGA has become the three-headed monster because the plaintiffs' bar loved it. They loved it because it had a lot of advantages over a traditional class action. What PAGA lets a plaintiff do is you could have a single disgruntled or unhappy employee or former employee, and they can sue and automatically wrap up all hourly people that work for your organization. And it can be people that, you know, do the same jobs they do. It can be different jobs. It could be different divisions, different departments, and they wrap them all into this case. A PAGA case is different than a class action because in a class action, you get the actual damages. So for instance, if it was off the clock work, in a class action, you can get that unpaid time. Or if it was an incorrect overtime rate, in a class action, you would get that actual unpaid overtime. In a PAGA case, you don't get those damages. What you get is a penalty. And the penalty is a per pay stub penalty because under PAGA, you get a penalty for every time the pay stub is wrong. And so the PAGA statutes allowed for a $100 per pay period penalty per employee per violation on the first violation. And then what the law said was that on subsequent violations, it would bump to $200. And so when people filed these PAGA claims, that's what they were going after, were these penalties. So you may think to yourself, well, also talking about distinctions between PAGA and class cases. Class cases has a 4-year statute of limitations. A PAGA case only has a 1-year statute. So we'll talk a lot about this morning, but under a PAGA claim, the plaintiff will send a letter to the state of California outlining their claims. They have to do that before filing a PAGA action. They then have to wait 60 days before filing that lawsuit to give the state an opportunity to advance the claim, which the state almost never does unless you're Google or Uber or, you know, some sort of company where the state wants the positive press of saying they're advancing these kinds of claims. But I'm assuming for most of the people on this webinar, that would not happen. And so that statute of limitations goes back 1 year from when they send that letter. And so you're thinking to yourself, well, Sam, you sold me $100 and you said it's only a 1-year statute of limitations. Why the heck is this so bad? This doesn't sound so bad. Well, the reason is a couple-fold. One is under a PAGA case, the statutes allowed the plaintiff to get individual liability against a business owner or manager. Because what would happen is one of my private clients, that's maybe a small business owner, would say, well, Sam, let's just fight like heck. And if they pop this case at trial, we'll just file for bankruptcy and just tell them they should take pennies on the dollar because otherwise we'll file bankruptcy. And so what the legislature did a few years is it passed a statute that said that an employee or former employee can sue under a PAGA case an employer or other person acting on behalf of the employer. And they define that other person as a natural person that is an owner, director, officer, or managing agent. So for my, a lot of my medium-sized businesses and for all of my small businesses, when they were getting sued on a PAGA case, the company was getting sued and the owner was getting sued as well. And they did that so that if the defense ever said, we'll just file bankruptcy or we don't have money, they say, well, fine, what properties do you own? What investment accounts do you own? What sort of personal funds do you own? Because we'll go after all of it. The other reasons why PAGA had some...
Sam, can you quantify, like, what is a standard size or average claim value? I mean, are we talking millions? Are we talking tens of thousands?
Yeah, it's a great question. I mean, usually the claims that we would see for most of our clients, and look, I mean, our clients tend to look a lot like San Diego. So it's a lot of small and medium-sized businesses. So most of our claims for a company with, let's say, 50 to 150 employees, you're seeing claims of about $500,000 to $1 million. And we'll talk about how we get there now, right? So you may be thinking again, so why PAGA? Well, we talked about the individual liability. The other advantage is that there's no class certification. So if you're filing a class action, you have to show that your class representative is an adequate representative. You have to show that his or her claims look like the claims of all the other class members. You have to show that there's no individualized treatment of these people. You have to show that the class is big enough for it to make sense to the court. You have to show that handling it in a class action is the most effective way to litigate it. You have to go through all these steps. And traditionally, the defense bar would say, we're not even going to talk settlement until you get through certification. Well, in a PAGA case, you go wrap all these people in. They can't opt out. They can't say, I don't want to be in it. They're automatically in. There's no way for them to get out. There's no requirement to show that this class member that's filing the lawsuit is adequate. We've had cases where someone working in a warehouse sues, and not only sues on behalf of warehouse people, but office people that are hourly, drivers that are hourly, any hourly person. And the big thing, and the thing that gets to Fran's point, is that the math gets really high on these PAGA cases because they say $100 per employee, per violation, per pay period. And so if you have 100 employees, even a $100,000 penalty for one pay period, obviously you're looking at, you know, $10,000 bucks, right? Well, now you run that times your 24, your 26 pay periods in the year, and now you're at a pretty darn big number, right? So now you're at, you know, 240,000, 260,000, and that's per violation. And so what the plaintiff's bar says, well, you messed up meal breaks, 260. You messed up rest breaks, 260. You messed up overtime, 260. You messed up expense reimbursements, 260. So they stack all of these penalties on top of each other to all of a sudden come up with a very large and very expensive claim. And they'll get you into, they'll send the letters to the state, they'll ask for your time records, your pay records, they'll send it to an expert and they'll say, let's go to mediation. They'll show up with a massive number that knocks your socks off and makes you sick to your stomach. So we would see the same thing before these PAGA amendments. We see the same thing every time. We see the same PAGA form letter. You know, it would have very little analysis of what you did wrong. It'll have a page and a half of meal break law, and then it'll just say employer failed to provide meal breaks. That's it. You know, page and a half of rest break law, and then the same sort of one sentence, two sentences analysis of what you did wrong. And in San Diego, what we would see is we see a lot more of these PAGA claims by LA law firms. They're filing these all over the state. They're marketing them very aggressively. I was at a presentation yesterday where I talked to someone that he is doing outsourced labor in South and Central America, and one of his biggest clients is one of these plaintiffs' law firms that send these letters out all day long. And according to this guy, this law firm is using him to have outside labor in South and Central America that's just taking these intake calls, screening clients, and then drafting these letters for him. And he's laughing all the way to the bank. So we were seeing a ton of these letters, and it was really putting a lot of pressure on employers. And the letters had, like I said, all of these types of claims. And I put this letter, this bullet up here so you can see that stereotypically, this is about 90% of the wage and hour stuff we see. What I tell clients is if you can get these items, these 6 items correct, you're going to be, you know, 95% towards eliminating or drastically reducing exposure. All the stuff we see is meal breaks, rest breaks, overtime claims, expense reimbursement claims around uniforms and cell phones. We see a lot of allegations around time rounding and a lot of allegations around off the clock work. So the meal break things that we see a lot is either short meal breaks, untimely meal breaks, interrupted meal breaks is a big one. The overtime claims, it's shocking. I still get a lot of cases with employers paying the wrong rate of pay for overtime. I'm dealing with a very big case right now where a client paid employees 2 different rates depending upon the work they were doing in a work week, and paid, didn't do the correct calculation for the overtime rate of pay, and they messed that up. On expenses, we're seeing that a lot with companies that are requiring their people to clock in and clock out on apps, and the employee has to use the app to clock in and out, but they're not getting reimbursed for it. And then we're seeing a lot of time rounding claims, and particularly on meal breaks. You got to make sure you're not rounding on meal breaks. So,
one of the things
I have a quick.
Yeah, go ahead, Nicole.
I was going to say, I have a quick question on that, because I think what's interesting is that sometimes from those who don't live in this space, right, as an occupational hazard, they don't realize that PAGA actually covers anything in the California Labor Code. And so even though those are the heavy hitters that we see the majority, are you seeing things like employee classifications? We get a lot of that, right, with our clients who want to put people at the exempt level, but really they should be classified as non-exempt. And so for that reason, we have a lot of challenges there. Or they want to call them an independent contractor, and that's not what that is. Are you seeing that? And then also anything under OSHA or anything in that?
I have not seen anything under OSHA. On your misclassification stuff, I see those cases a lot individually. I don't see them advanced as much from the PAGA basis, because usually if you're misclassifying someone, maybe you're misclassifying 3, 4, 5 people or something like that. We usually don't see that done broadly enough where it makes sense to advance that as a PAGA case. So I haven't seen that as much on the misclass on exempt or non-exempt, but we do see a ton of those cases, and I remind clients all the time. I mean, particularly on making sure you get the twice the minimum wage calculation correct. I'm defending 2 cases right now where the client was paying someone salary and not paying them the minimum salary threshold for exempt. I beg you to get that right.
Yeah, the other thing we see when we go in and do assessments is oftentimes our clients are making an assumption that if they've got a payroll company, the payroll company has this all covered. And it's a poor assumption to make. Joelle, I don't know if you've seen that in your travels, but payroll processing is very detailed. And as you say, Sam, overtime is one of those things where we just can't get it wrong. And the payroll company isn't doing that. It's the payroll processor or whomever's working in the client that's doing that. Are you seeing that too, Joelle?
Absolutely. And that was one of the questions I was going to talk about, is not only just verifying the systems and like the calculation, but there are system glitches as well that you have to verify. So when you are looking at payrolls, do the audit, like Sam was saying, verify that the overtime is being calculated correctly, verify those things, because it happens a lot. I can't tell you how many times there's like an upgrade in the accounting system and all of a sudden the calculation kind of goes off a little bit. Not that I'm saying all accounting systems are like that, or sometimes the rule, there's lots of rules in there and then we just supersede rules in the accounting system. So just verifying your data is your best way of making sure that it's calculated correctly every payroll. Thanks, Fran.
Well, is not only, to your point, Fran, is it an issue with thinking that the payroll company's taking care of it. The big one I see is, oh, well, we're with the PEO, so we don't have exposure. And what happens, and this is not all PEOs, but when the PEO is selling to you, they're going to sell it to you as like, hey, you go with us, we're going to take over all this, you're not going to have any exposure, you're not going to get sued for wage and hour claims, blah, blah, blah. Then when you get the nasty grant from the plaintiff's lawyer, the PEO is going to go to you and say, well, look at the contract under, paragraph 14, little a, it says that if you get sued by this is all on you. And if they try to bring us into it, you have to defend and indemnify us on those claims. So, also, just because you have a PEO does not mean you're immune from this stuff.
I think that's a great point, Sam. Yeah, only because we deal with that a lot, to Brent's point. Also on the HR side, which is they think that the payroll companies actually hold the liability because they're processing payroll. And they are shocked to find out when they file the taxes incorrectly or, whatever it might be, that they take the stance of, we're just here to process. Ultimately, it's the employer's liability to get it right. And you're there to have an internal control in place and get it right. So you have final approval. We just process.
Yep. Yeah, I mean, it's amazing things we see. Payroll companies will literally do whatever you input. I mean, it's shocking sometimes. I mean, things that I've seen with clients where, they'll let a client put in, 11-hour days for an employee with no overtime. Nothing gets flagged. They'll let an employee, or client have someone that's on, salaried making $1,500 a month. No flagging of it, no conversation of it. Wait a second, you want to talk about this? I mean, they are not generally very helpful. So.
Another thing I've noticed too is California has very specific rules compared to other states. And so usually when you buy this, it's right out of the box, and you have to go through all the California rules and laws to put that in there. And so it's part of the company to ensure that those are set up correctly for every state that you work in. And I've seen a few errors that way where we're like, oh no, that's not the way you count overtime in California because they think we're in Utah or somewhere else. So it's those little rules that you have to really be careful on.
Yeah, I tell clients all the time. I mean, it's kind of become the sexy thing is to have 10 employees in 8 different states, but it's 8 headaches. I always encourage clients, if you want to hire people outside of the state, pick 1 or 2 other states. And I mean, if you can't find people in 3 states, maybe there's a different conversation you need to have about why you're having such a hard time finding people. Maybe the answer isn't finding 5 additional states and trying to find 5 different state employment laws you got to comply with. So, any other questions on this stuff?
It's a really good point on the multi-state. It opens a can of worms in a variety of areas, on your tax piece, on nexus, on employment law. So it is something to consider before you end up in 50 different states. For certain.
I did actually have a qualifier on that, Sam, with respect to, because I think a lot of people who don't do business necessarily or not headquartered here, right, that they think, oh, okay, I don't really have to worry about this piece. But when you have employees who are in the state of California, or if you have employees who are coming in and doing work in the state of California, that all obviously encompasses you, open yourself up to that liability, correct?
Yeah, I mean, stereotypically, the law where the employee is performing the work controls. So that's not to say that, if the employee is 99% of the time working in Tennessee, for instance, and they come out here for one conference, that all of a sudden all of the California employment laws apply to them during their employment. But the point being is you can't, just because you may be a Nevada company, if you have a remote workforce that is living and working out of California, this stuff applies to you for that person. Now, they're not going to be able to wrap up your Nevada people, but it certainly applies to your California people.
Yeah.
Okay, so as far as the new law, went into effect on July 1 of last year. It was in effect immediately, and it didn't apply to old cases. Okay, so this is the big one, and the one early on when I was giving these presentations, the question I was getting. It only applies to PAGA cases filed after June 19th of 2024, and nothing before that. But at this point, we're far enough out from June that anything new that you or your clients get, this is going to apply to. One of the helpful things that it does is it restricts that standing requirement. So I mentioned before that under the old statute, one bad employee or former employee could sue on behalf of everyone, and that was regardless of whether or not that person even suffered the actual violation. And so what the statute says now is that named plaintiff has to have actually suffered the violation. If he or she never had a meal break issue, they can't advance a meal break issue. If he or she never had an overtime issue, they can't advance that issue. And they had to have suffered that issue within that 1-year statute of limitation period now. So that's helpful. It's not, amazing, but every little bit helps. And so at least it gives the defense lawyers, some arguments on reducing the scope of the claims. It also allows for some cures for wage statement violations. So one of the things that made PAGA really onerous is you would be a business that's ABC Inc. doing business as TencerSherman. And so on the pay stub, you will put TencerSherman. And that wasn't the correct corporate name. And under the old statute, that one mess up could cost you, again, like hundreds of thousands of dollars. Or maybe you changed addresses and you didn't bother to tell your payroll company you changed addresses. And so when the pay stubs went out, it had the wrong address on it. That could be an insanely expensive mistake. And it was silly. Like, the employee wasn't harmed by it. It was just this technical error. So now what this law says is that if that issue comes up, you can cure it as soon as you provide written notice and the correct information to these employees, and there's no claim. So that's a big one, because we were seeing the plaintiffs bar leveraging those little trivial mistakes a lot. The new PAGA penalties are also reduced, where now it's only $100 per employee for the initial violation, and it remains at $100 unless and until an agency or a court finds against you, or if the court finds that your conduct was malicious, fraudulent, or oppressive. And that's a pretty high, legally, that's a very high bar that courts are usually loath to implement. So, this amendment alone reduces the plaintiff's argument on the scope of the damages in half, right? I mean, if we're limiting to that 100 and not that higher 200, that's super helpful. It also provides two really significant cure opportunities. Okay, so we talked about that letter that the employee or the employee's lawyer will send to the state. The state department they send it to is the Labor Workforce Development Agency, or the LWDA. You're going to know you have a problem when you get that letter from a plaintiff's lawyer that's going to be addressed to you, and it's going to be addressed to the LWDA. And so now what this statute says is that if you demonstrate that before you ever got a letter to the LWDA, you took all reasonable steps to comply with the law, then the PAGA penalties are reduced by 85%. Okay, the penalty will not be more than 15% of what's sought. This is a huge reduction. And so what I'm really encouraging people to do is do what we're going to talk about on the next slide, because your logical question is, Sam, that's great. What the heck is a reasonable step? Well, the court says it's evaluated by the totality of the circumstances and based on your size, but they suggest regular payroll audits, compliant policies, wage and hour training, and discipline for violations. So this is something we've been partnering a lot with PBO on. It's not something I do. Our office, our firm does not do these regular audits, but PBO's been doing them. We've worked with them on clients. They're doing an amazing job on them. And that 85% reduction is so massive that I'm really encouraging clients annually. You should bring someone in. I really recommend a third party, because when you're trying to establish that you're taking these things seriously and trying to get that 85% reduction, I think showing that you hired someone outside versus doing something internally, you're always going to hear from the plaintiff's bar, oh, well, you did it internally. There was a pressure not to find issues. There's a pressure to gloss over things. Like, to the extent that you can show that every year you're updating your handbook, you're auditing your payroll practices, you're interviewing employees to make sure things are being done right, you're training your managers on off-the-clock work, not texting people outside of work hours, not interrupting meal periods, auditing clock in, clock out procedures, things like that, and you keep records of it, right? So you have a file somewhere for every year what you're doing. I think it's insanely powerful. So I really recommend everyone, if there's a couple lessons learned from this presentation, this is one of them. Take this seriously and to heart. Annually, I would do this stuff, because an 85% reduction is it's extraordinary. And if it costs you, 5, 10, 15,000 a year to reduce $500,000 or $1 million in exposure, you're going to wish you did it. So I'll get off my soapbox on that, but this is a really powerful component of the statute.
I have a quick question, Sam, circling back to the LWDA. Is it also accurate to say that, or if you get a request for a personnel file, does that start the clock?
So that does not start the clock. And what Nicole's mentioning is, I mean, stereotypically, we know we have a problem with an employee or former employee when they send that letter requesting the personnel file and pay records. And usually that is the precursor. Usually it goes that request, then a letter to the state, and then the lawsuit. But no, the audit is going to be focused on if you're doing it before that LWDA letter. But again, remember that one day you're going to be negotiating whether you should get that reduction. And it's going to be much more powerful to argue, look, for the last 3 years, we've done this every year and we never had an LWDA letter. Versus like, oh, well, we got the letter for the request for employee, personnel file and pay records, then we brought PBO on, then we got the LWDA letter, right? So I think that, it's still not necessarily too late to do it once you get that letter, but you're going to be in a much stronger position if you're doing it annually. Good question.
And so
Thank you for
Bring in-
clarifying.
I was going to bring in as well from that last slide that you're talking about reducing the liability. It's not only for the organization, it's also for the individual. And then the cost of the audit versus the cost of the liability is a huge bang for the buck for the agency. So being proactive, and even though the cost of the audit may be a small fraction, but the fraction to the whole PAGA could be, it's minimal. So it just sounds like a very much of a no-brainer.
Yeah, I mean, if you think about a 15% of $1 million versus $1 million, I mean, it pays for itself tenfold, plus all the headache and hassle of, no offense, Sam, but dealing with lawyers and those sorts
Dealing
of
with
things.
Sam.
Well, it's also all the
one of the questions I have on the cost side is, what about insurance, EPLI, and what does that come into
D&O.
play? If you get a letter like this, like what are your actionable items?
Yeah. So we'll definitely talk about the actionable items. I mean, two things on what you said is one is here's what happens. Here's the reality of what happens. And those of you, Fran and Nicole, that know me know I'm blunt to a fault. Every employer thinks this is not going to happen to me. Every employer, oh, Sam, I've been in business 15 years. I've never had a problem. And like, that's the statement that makes my skin crawl, because, if you've had a good run, congrats. Consider yourself lucky, but don't think you're immune. I mean, do not think you're immune. Don't be penny wise and pound foolish, because it's gotten to the point in the state where everyone is getting these things. That's a B on Fran's last question. Insurance is a tricky thing. So, everyone should be considering what's called employment practices liability insurance, EPLI. It can be good or cannot be good, but you should at least get a quote and figure it out. Usually those EPLI policies will cover harassment, discrimination, retaliation, things like that. If you have a lawyer that you want to use if you get sued, let the insurance company know at the time you're negotiating that policy. If you wait until after a claim is filed, you're likely going to have some lawyer forced on you. Sometimes they're good, sometimes they're not. The trick with the wage and hour is usually wage and hour is carved out. If it's not carved out, stereotypically it's a very high deductible, about $50,000. And then you'll get about $100,000 in legal fees, and they won't cover any damages. So any settlement won't be covered, any jury award won't be covered, none of that will be covered. So I'm not suggesting you don't do it, but I think you want to be thoughtful about it, because based on the cost of that policy, paying premiums every year so that if you get sued on a wage case, you have a $50,000 deductible and then $100,000 in legal fees covered for a lawyer that you don't know and you don't want. I mean, it may be worthwhile, but it may be something where you just don't want to do it. I mean, I've had clients that have coverage on wage and hour and don't even use it because they want to, they're going to lose having me represent them. So it's just something to be eyes wide open about. But everyone should at least be calling their broker to at least consider it.
And what about the D&O insurance? Because you talked about, right, like the liability for directors and officers, et cetera. Like my understanding is D&O doesn't cover that necessarily either. It's carved out.
I've never seen that covered. I've never seen D&O coverage covered. Again, sometimes it'll cover those harassment, discrimination, retaliation stuff, but generally speaking, there's a carve out on wage claims.
So that's really important, Nicole, particularly Joelle, with the many nonprofits that you work for, board members. We all sit on nonprofit boards, and we have fiduciary responsibility there. So it's really important for us to make sure that we're mitigating our risk wherever we can. Hence, looking at our practices to, at least if we get a claim, we can minimize the penalties.
Yeah, for sure.
And Fran, what you're saying as well is informing the board, having those audits, being able to have those conversations, and yes, we did this and this is why, because we're mitigating those risks, those fiduciary amount, because for some small nonprofit, that's the whole bottom line. And this is cash, like this is penalties and fines, and it's not like we can, throw money right now. So yeah, it's a hardship.
We can't pass that to a grant for certain. That's straight overhead cost. There's no doubt about that. Okay, Sam, we could talk about this forever. We better not interrupt you too much more.
No, this is good stuff. So we scared you. We told you about the annual audit. So what happens if you did do that or didn't do that, but then you get the LWDA letter? Well, there's still things you can do, right? So you can do an audit at that point, and you can still get a 70% reduction on your PAGA penalties. Okay, so what you have to do though is you have to take quote unquote reasonable steps within 60 days of getting that letter from the state. And if you take those reasonable steps, then again, the penalty cannot exceed 30% of what's sought. And again, the legislature has helped us sort of define reasonable steps. It includes auditing potential violations, taking action in response, disseminating or redisseminating lawful policies, training supervisors on compliance, taking corrective actions on supervisors, things like that. So again, we've done a fair amount of this since this law passed in June of last year. We've collaborated with PBO on it. We have one active plan we're doing right now with them on this audit and cure. The big lessons learned on this is that when you get that letter to the LWDA, you got to call counsel immediately, and you got to call employment counsel immediately. Don't call your business transaction lawyer. Don't call your estate planning lawyer. Don't call the guy or gal down the street that does criminal law. Like, find a good employment lawyer that does this stuff, that knows this stuff, and have him or her take charge on it. Because again, we're not going to do the audit, but we want to quarterback it, and we want to make sure it's done in a way that when we have to defend this darn thing, we're as confident as can be that it's ironclad. And you think that 60 days is a long time. It is not. 60 days flies by, because you're going to get that letter. You got to get counsel involved. You got to get PBO involved. You got to go out. You got to audit the policies. You got to audit pay stubs and time records. You got to interview people, and then you got to determine what you found and take corrective action, all within 60 days. I mean, that is a lot to handle. It can be done, and we're doing it, but point being is you got to jump on it, and you got to be proactive about it.
Yeah, you have to mobilize. I have to say really quickly, it's something we've worked with Sam's team a lot on, and it comes quickly. There's a lot of moving parts, a lot of players. We're trying to manage, right, and mitigate the messaging, right, working with Sam and his team to the employees so that they understand what's happening, right? So there's just, especially right now with what's happening in the world, there's a lot going on. And so to pull all the teams, right, and take their bandwidth, their opportunity cost of what's happening, it completely, crashes everybody's mind share on like just having to focus on this. So there's the impact financially of the outcome, right, from cost perspective of what actually is mediated and what the cost actually ends up being, right, from a penalties perspective or damages perspective. But there's also this opportunity cost to the employers of just the bandwidth and the brain power it takes to like mobilize all of these teams. Sometimes we're on client sites of our, not just our client, but their clients, so it's incredibly impactful. And it's a lot to manage in one round. So we often will have our clients call us first. We don't actually have us, that's not our preference. We'll immediately pick up the phone and call Sam and say, we have an issue and we need to mobilize quickly. So it is really important, to Sam's point. Don't delay. It takes a lot of time to get a lot of players in place.
Yeah, and we also, I mean, what was really rough was the end of last year where, within that 60-day period, we had clients where Thanksgiving fell within that, Christmas and New Year's fell within that. And so now all of a sudden you're taking a 60-day period and you're cutting out a week or 10 days from it based on the holidays, and it really got cumbersome. So it's really the most important thing. Make sure your address is correct with the state of California, so you're getting the letters, and make sure you're moving on it. A couple of the other smaller tweaks to the statute. We didn't talk about this before, but one of the quirks of PAGA is that every dollar that's recovered, 75% is supposed to go to the state and 25% to the employee. This balance was shifted in the statute where now 65% goes to the state, 35% goes to the employees. There's a new rule if you're paying weekly. So we have a lot of clients. Construction can sometimes pay weekly. Home health can sometimes pay weekly. And again, remember that these PAGA penalties were assessed per pay period. So if you were paying bi-weekly or bi-monthly, you had 24, 26 opportunities per year for these penalties to hit. If you're paying weekly, you had 52 times a year for these penalties to hit. It was insane. So now what the legislature says, if you're paying weekly, the total penalties that you could be exposed to will be reduced by 50% so that you're not getting hit so hard because of your weekly payroll. But I really encourage clients, like, unless there's a darn good reason, move away from weekly if you can. And then there's also some early settlement options, right? So the logical question is, well, Sam, that's fine. We've taken these corrective actions. We've done these audits. Well, now what? Now what do we do with it? So if you have 100 or more employees, once the lawsuit's filed, you can request an early evaluation conference once you've been served with the complaint. You can also ask the court to put a hold on the case so you don't have to incur a lot of legal fees while you have this early evaluation conference. But you have, again, a small window. You have to request this after the complaint's been served on you, but before you've responded to the complaint. That's only a 30-day window, right? So again, you got to jump on this stuff quickly. And when you're requesting that stay in that conference, you have to include a statement to the court regarding your cure intentions on items that you found you messed up and what you dispute and claim you didn't err on, right? So you got to, again, make sure you've done that audit so you can give something comprehensive to the court when you're asking for that evaluation. If you have less than 100 employees, there's also options for you. And this went into effect in October. Now we're well past that. So there's kind of two things you can do if you get this letter or this lawsuit filed and you have less than 100 employees. So first, you can send the LWDA a confidential proposed cure plan within 33 days of receiving this LWDA notice, right? So, I mean, think about that. Now we're not just talking about a 60-day cure period. Now we've shrunk that because if you want to try to get the LWDA to throw this out, you have a 33-day window to do that, which is insanely tight. So now not only do you have to finish all these things we've been talking about on the audit and the cure, but you have to get that information to me in time for me to turn that around to a letter to the state within 33 days, right? So that's extraordinarily tight. If the state finds you cured the violation, then they can find that the civil lawsuit can't go forward. If they don't make that finding, you can still ask for that same sort of early evaluation conference we talked about. And so you're going to, again, point out to the LWDA anything you find is in dispute and anything you cured. To establish a cure for something that you messed up, you have to show that you went back 3 years, you paid back wages, you paid any interest or liquidated damages for unpaid minimum wage, and then you paid any amounts for reasonable attorney's fees, which, who the heck is to make that decision? So there's going to be a lot of fight on this. We've had one of these that we sent to the state to try to show a cure and what was in dispute, and the state punted on it, which I think is what's going to happen most often. I think that they're just going to not, I think it's so much to expect a state employee to look at your letter and say, oh yeah, this was 100% cured and the case can't go forward. It's a really high burden. So I think that they're most likely going to continue to just punt on these letters, but it's worth a shot. And it's worth a shot as far as resolution. I mean, to the extent that you can send that letter to the state, even though it's confidential, you could think about, well, maybe even though it's confidential, maybe I want to send this to the plaintiff's lawyer to show him or her that I'm doing things right, I'm taking this seriously, show them that they're at risk of not being able to go forward with this case. So maybe take a settlement that's pennies on the dollar because they're afraid of losing the whole darn thing. And I think it can be an effective strategy in that regard as well.
Does the clock stop ticking then on like the interest penalties and all of that if you send that letter?
Well, it's going to stop once you've cured. And so that's why the really big issue on these cases is taking it seriously and curing. You know, before these amendments, we used to have these conversations with clients, you know, do we want to cure or not if we find something? But you have to cure on these PAGA cases, one, because of these reductions we've been talking about. But the other reason it's insanely important to cure is remember that that statute of limitations is only 1 year from the date of the LWDA letter. But if you don't cure it, that clock keeps ticking every day that passes and you don't cure. So if you wait and you don't cure and you go to trial in 2 years, or you go to mediation in 1 year, they're not going to say, well, you have a 1 year statute. They're going to say, well, it goes back a year from the date of the LWDA letter. But you sent that letter a year ago, and in this last year, you haven't cured. So now that window is 2 years because you never fixed it. So that's why when you get these letters, it's just another reason why this cure is so important. You have to jump on it. And it requires—
The interest on the penalties is 7% annually. I mean, that's no joke if you're talking about $1 million, you know. Yeah, okay.
100%.
Wow.
I have a quick question for you, Sam. One of the things we get a lot, and I'm sure you do too, from our clients is, oh yeah, no, we're experts on PAGA. We've already been through one of those, so now we've got it. We know what we're doing. Can you speak to that? Because we run into that a lot, and it's what they don't realize is, no, this is not a one-time like drop in the bucket. Like, this is a continual improvement, and there are laws that change all of the time, and that's where we see things sort of come off the track, is they think, no, we've been through this, we're battle tested, and now we're good to go. Are you seeing the same things? Like, can you speak to that? And if you have already been through one and then demonstrate, I think what they are appreciating is if it happens again, it probably looks even worse, right? Because now you are clearly a repeat offender.
No, I think you're right. I mean, there's a few things we hear a lot of, right? We hear a lot of on any of our cases. Oh, well, you know, because I'll talk to the client. Well, look, I mean, you haven't had a handbook. Let us do a handbook for you. Oh, you know, you messed up this. Let us fix it. Sam, let's just get this done, and then we'll go back and fix it. And what invariably happens is it never gets fixed. I mean, it's shocking how often it never gets fixed. And so you have to fix it. And to your point on like, we're a big company or we're sophisticated, I mean, I get a list of every case that's filed in the county of San Diego every day. And it's not just small businesses. I mean, big companies are getting sued for this stuff all the time. So just because you're big or you think you're sophisticated does not mean that you're doing things right. I mean, it's the same thing sometimes with your internal HR people. They could be really good on certain aspects of their stuff, but they may not, you know, 9 times out of 10, they don't know what's going on the front lines. They don't know about that supervisor that's interrupting people during their meal breaks, or telling people to work during their meal breaks, or, you know, doing these kinds of things. And so you have to do these, you know, you really have to do the audits, and you have to, the mistake that companies make is, you know, my HR person is really smart, he or she can do the audit. Well, just because they're smart, if they've never done the audit before, do they know what the heck to do? Do they know how to do it? Are they consulting with legal on where they've seen pitfalls and best practices and whatnot? And if not, you're setting that person up to fail. I mean, it just doesn't make any darn sense. You know, I mean, they may be great at, you know, some aspect of HR. It doesn't mean that they have this expertise. And the number one mistake I see companies make, particularly with HR, is, you know, you got someone that's really good on, you know, benefits and culture, and so you think that person's a wage and hour expert. Well, they're not. They're just happen to be good on, you know, a certain aspect of that HR job. So that's a big thing that we see a lot.
Yeah, and that's why we have auditors, right? It's having someone who really understands the minutia and taking a look at it from a, you know, this other lens. I see you know, you mentioned that we're seeing more suits every day. Are you seeing certain industries that are being targeted, or are there certain industries that need to have best practices, like nonprofits who have volunteers or construction teams that are out in field? Do we need to be paying attention as an industry about certain best practices?
It's a great question. I don't know that I'd say that there's any specific industries that are targeted any more than others. Sometimes you'll see trends where, one plaintiff lawyer will file something on behalf of, one type of group, and then that all kind of triggers. I mean, a few years ago, there was a lot of hits on like beauticians, barbers, things like that. Home health gets hit a lot. Usually what I tell people is the more complex and convoluted you make your compensation structures, the more likely you are to get sued. You got to think about if that employee walks into a lawyer's office, if that person says, oh, I was getting paid, 3 different rates and 1 overtime rate, that's going to trigger commissions, trigger conversations, piece rate work, that makes lawyers salivate. So it's more of those kind of practices type things that I would say. But we're getting to the point, I would say, in the last 12 to 18 months that the plaintiff's bar will send a demand letter on anything. I mean, we see atrocious demand letters. I mean, it used to be 3-4 years ago, it wasn't, usually a demand letter, there would be something where you messed up. I mean, anymore, they don't care. They don't even care about the facts. I mean, they'll send me PAGA letters and I'll try to have conversations with them about the claims. They don't even want to talk about the claims. Just get me your data, get me a list of employees with contact information. We're going to start calling everyone, and they don't even want to talk about the merits. I mean, it's crazy. And that's, going to kind of the trends and what we're seeing. We're seeing a lot more class actions right now. We're seeing a lot of lawyers filing separate lawsuits, one for class claims and one with PAGA claims. And we're seeing the plaintiff's bar really sending these letters to the state and then going radio silent in the hopes that we mess up on the cure. And what we're seeing is they'll say, and I had this conversation with the LA lawyer a couple of weeks ago. In fact, it was with the client that we're working on right now with PBO on, where I'm talking about the merits, and she's like, well, you messed up this one thing. And I said, well, why don't we discuss settlement instead of making us pay all this money on the cure? And she goes, no, that's okay. She goes, how many employees do you have? And I told her how many, and she goes, no, that's okay. We're just going to amend to add class claims, and it doesn't matter if you cure. So, they're going to still figure out ways to get around this. I do think it's going to lead to a lot more class allegations. And those tend to be kind of the trends that we're seeing on this stuff. So I think this is my final slide, just to kind of quickly go through this, and we'll go to kind of the panel and the Q&A. What do I see going forward? Again, regular audits, do training, call counsel ASAP, check on the California Secretary of State website, your agent for service process, so that if you get that letter sent, it's going to the correct address. And arbitration agreements can be very helpful to avoid PAGA cases. I would heavily consider implementing an arbitration agreement. I'm not saying to do it, but consult with counsel on it. It can be really helpful. So with that, those are my talking points, and now we can kind of turn it over to the group, to more of the group discussion.
We do have a couple of questions in the chat. One is, what is the minimum salary rule? And I'm assuming that's for California, but maybe we can talk Fed and California.
Yeah, so usually to fit into the exemption, or to pay someone a salary, you have to fit into the quote unquote exemption. And so there's different exemptions. The 3 main ones require you to make more than twice the state minimum wage, right? So it's not it's not the minimum wage you may be dealing with in your locality, but it's twice the state minimum wage, which is almost 70,000, like 68,640 right now, I believe the number is. And so you have to make sure you're hitting that number. Now there are some different classifications if they're exempt because of the IT, there's an IT exemption. That's a different one that's much higher. They could be exempt from overtime and meal rest break issues if they're outside sales. If you have outside sales people that are spending more than 50% of their time outside the office doing sales activity, there's some unique things. But otherwise, any of the other exemptions, it's going to be twice the state minimum wage. But that also applies in really pretty much, well, in every state in the union, because also these same rules apply federally. And so the federal law applies to every state. So even if you're in a state that doesn't have its own minimum wage rules or rules on exemption, you're still going to default to the Fair Labor Standards Act, which still has twice the minimum wage requirement. Now, because we're in California, I don't even remember right now what the minimum wage is federally, but it is lower, but it still exists. It's definitely a lower threshold.
So one of the questions, and there's a comment in here too, is that for nonprofits, sometimes they have volunteers or grant funded positions. Does the PAGA law, how does the PAGA law impact those types of roles?
Yeah, I mean,
volunteers aren't being paid.
Volunteers is a whole, I could do probably a half-hour presentation on volunteers and how to legally fit someone into that volunteer definition. And so, you know, volunteers can get you around that minimum wage issue, but just because you're a volunteer just because you're a nonprofit doesn't mean you can make anyone you want a volunteer. So just be careful on that. Make sure you're looking at the rules. I actually did a blog post on this a few years ago. I can, you know, if anyone wants it, I can get it. But I mean, the main rules are that you're not displacing another person. It's not for your benefit. It's for their benefit. You know, those are the main things you're looking at. 9 times out of 10, once you start looking at the rules, it's pretty rare that it actually, you know, you feel comfortable not paying them. But you know, there are ways to do it, but it is tricky.
There's also a comment in the chat that says that if you are a nonprofit, the board of directors is actually responsible for the penalties financially. So we might want to dig into that and look at bylaws, but if you're on a board, I would really make sure you understand what your liability is here and how you can mitigate risk. So that's actually one of, maybe we end here and we can go and each of you can answer this last question. And this is basically, given the ongoing labor and regulatory environment in California, do you anticipate further reforms or legal challenges in PAGA in the future? And how should employers prepare for potential future changes?
That's a great question. I don't have any crystal ball. I mean, I can't say it was going to be amended. I think the best thing is to focus on where we are now. I mean, you know, it took a pretty monumental effort to get this done. And this was pretty substantial. I mean, usually when the state makes changes, there's little degrees here and there. I mean, this was pretty substantial. I don't personally anticipate anything drastic, but who knows? If you would have asked me in 23 if I expected the amendments we had in 24, I would have said no. So, you know, that crystal ball question is always a tough one. But I think the main thing is to kind of focus on where we are now and what we can do now with some of this stuff, and really being thoughtful about, you know, these audits, again, about arbitration agreements, some of these other things you can do to kind of get ahead of these things.
Yeah, I mean, in a way, this is a win for the employers. It doesn't feel like it because it's a heavy lift, but at least we have an opportunity to mitigate some of the risks. So what are some of the thoughts that you have? Each of the panel, you can actually talk about this. And Nicole, maybe you start as, you know, prior to getting a letter. I mean, let's be proactive, because once you get the letter, we're in scramble mode, right? We're in cure mode. But there are things that we as employers in California can do today to mitigate this risk. So I'm going to hand it over to Nicole, and then we'll go to Joelle and then to Sam.
Yeah, so to circle back on the last question quickly, I don't have a crystal ball either, couldn't tell you, but what I know it's the state of California, so we like to mix it up and make it complicated, I can tell you that. And I think the most important part on that is just surround yourself with the right resources so that you have the ability to make good business decisions, right? So whatever that looks like, every company looks different, whether it's an internal resource or an external resource. So reasonable steps in terms of what to do now. We really focus with our clients, and we work a lot with Sam and his firm. He is an attorney of choice for us, so that we work with their firm often. So and it's because they live in this daily, right? So the audits are really important. So we look first and foremost at the hard copy data, right? So governance policies, we look at things like what's your process look like? What do your systems look like? Are your systems set up correctly to, you know, accrue PTO correctly? The new stick regulations that have come out, all of those things. We sort of look at the hard and fast data from payroll audits, timekeeping systems. So that's sort of the first piece that we look at. The second piece you can look at is the behavior surrounding it. So policies are great. Hard copy is data is great, but really where we see people fall down is on the behavior of the front line of defense, where the managers, and oftentimes it's about putting in the budget, right, to like invest in compliance and in training, and creating a culture that is around safety and just knowing that you're trying from a brand perspective, right, to really do right by your employees, and that you want your employees to get paid correctly. You want them to have what they're entitled to. So beating that drum is really important, integrating that. So the training is really important, doing behavior checks to make sure that, you know, they understand what the law is, how to interpret that law. I can't tell you how many times we run into a client that says, well, what do we do with this? And it's like, well, what did you say you would do in your handbook? And they're like, what handbook? And we're like, okay. So there's a lot of that, right? Like, what did we say we would do in our handbook? So the other thing too that we see as an often miss is there's no feedback loop for the employee. We need to provide, whether it's anonymous or options for them to come to the table directly to the employees. If our managers, the other thing our clients can do is put in a feedback loop for employees to report it. 9 times out of 10, if we can work with our clients to get to it ahead of time and squash it and handle it, they just want to know that we're going to do right by them. So that's where I'd start.
And Nicole, Nicole brought up a lot of points that I was going to talk about. Definitely in your budget, you know, when you're working with your CFO and your CEO, and you're right now, a lot of people are going through their budgets. Ensure that you have your training. Do your trust and verify. Not just the training of knowing how to calculate your payroll, but also talking to your managers. How does that look at? The culture training, making sure you have your audit set up, ensuring that your board is set up. Review your policies and procedures annually. Like Sam said, you're supposed to have these put, and then all of a sudden it just kind of gets drifted. So kind of keep those items on the front edge, because those are the things that you're going to be looking at when, you know, you have a claim. What's your policy and procedure? What's your handbook? What have you done? And then do your test and verify. I can't tell you how much time I spend with my payroll people verifying overtime, calculating random timesheets just to make sure that it looks right. Like I mentioned earlier, system glitches happen. It's good to catch it first before somebody else will catch it. So those are just kind of like more detailed things, but high level, definitely the fiduciary risk, your management risk are things that I would look at. Sam?
Yeah, no, I think all the things that we've talked about, I mean, I don't really honestly have much to add. I mean, I think the biggest thing is really, the biggest lesson learned, I think, in going forward is really this annual audit aspect and really taking it seriously. It's really the best thing. You'd be shocked the errors I see from very sophisticated companies all day long. I had a conversation with a guy that I know well about his wife has 3 different clothing stores. I talked to him 2 years ago, just about her. Oh, they're so dialed in. Oh, they're amazing. Oh, they got everything perfect. Well, then, they got slapped with a lawsuit. I mean, they made so many stinky mistakes. It could have been fixed so easily. But, no one thinks it's going to happen to them. So I really think that this cure is the biggest thing.
I mean, the return on investment between legal fees and loss of productivity, brand impact, all of the things, not just the penalties alone, it's absolutely worth it. I can't, put on my CFO hat and say this is a no-brainer from a risk mitigation point of view and a return on investment. It's just best practices, and probably we need to look at that as employers to be able to make sure we're ensuring the most return on investment for our resources, both financial and human. So we are out of time. We could talk about this all day long. Thank you so much to our incredible panel. Thank you, Joelle. Thank you, Nicole. And thank you, Sam. If you all have any other questions, you can reach out to us directly. Like I said, we will be sending this the recording out, and you can contact any one of us if you have further questions, or if we can support you in some best practices to put into place to mitigate your risk on PAGA claims. Have a wonderful day. Enjoy it, and we will talk soon. Thanks, everyone.
Thanks, everyone.
Thanks.